Welcome to the academic session 3. It's always a strange name, calling it an academic session, as is all the other sessions are not academic, of course. So we have a nice panel here of 4 speakers, 4 papers. The first speaker will be Ogunde with the title Artificial Intelligence and Employment Law. Second speaker will be Pablo Baquero on Unveiling Transparency in Privacy Enforcement across the EU. Third speaker will be Claudia Diaz, who's going to present the paper she made together with her 2 colleagues, Preserving Privacy with Technology. And the last speaker is the CNIL-INRIA Privacy Award winner, Alexandre Debant, and we're going to present the paper he made together with his colleague, Reversing, Breaking and Fixing the French Legislative Election e-voting protocol. So the way we do this is that all of you have around 10 to 12 minutes to present. Then we have after each presentation a short Q&A, 5 to 7 minutes. And in the end, if there's time left, we can still have, of course, a general discussion on the papers. But first of all, let me give the floor to Ogunde with their paper, his paper on artificial intelligence and employment law. That's for the slides, I think. Yeah.
Okay. I have to stretch a bit. Okay, my name is Fife. I am a consultant with the government of Saskatchewan in Saskatchewan, Canada, which is a bit of a long way from here, but so my paper is on artificial intelligence and employment law, looking at it through a Canadian lens, and because obviously that's a very broad subject, or it's a very, very broad coverage. I'm particularly focusing in my paper on 2 aspects of employment law that are impacted by artificial intelligence. And okay, I'm trying to
click apparently, guy in the back says. Not working?
Okay. Thank you. Okay, so I'll be focusing on 2 major areas, which is artificial intelligence in hiring and algorithmic management. So in terms of artificial intelligence in hiring, I'm sure many of us in this room would probably be aware of the proliferation of automated hiring systems, where essentially, you have an artificial intelligence system kind of scan resumes for compatibility with the job description and things like that. And I'm sure as many of us who are also active on LinkedIn would see various recruiters or various people saying, make your resume compatible with an ATS system. And we have all kinds of advertisement related to that area, but it just shows the impact artificial intelligence is starting to have on hiring, where most resumes are even rejected before they get to be examined by even a human being, because of the working of those systems. Now, in terms of the benefits, of course, it increases efficiency in processing of resumes or job profiles, but at the same time, because it's based on the workings of an artificial intelligence system, there are otherwise qualified candidates that can be easily excluded because there is something about their resume or there's something about their profile that does not comply with the system. And so we have such cases where it's as though there is a candidate because of possibly a particular name or a particular skill set, or the absence of a particular skill set in a resume is automatically rejected. And that just shows one of the problems with this working of artificial intelligence in hiring. But an even bigger problem is the issue of possible bias and discrimination in those systems, because essentially they're trained on a particular set of data. So if there's anything biased in the data or anything discriminatory in the training data, it would inevitably translate into the workings of the artificial intelligence system. So we find that there's this famous example of a screening system that was developed by Amazon, I think it was in 2018, which Amazon couldn't put out for usage because it was found based on research that it excluded women in its screening criteria. So that's just an example of how these systems can actually perpetuate existing biases or existing discrimination. And there's a lot of academic work that has actually gone on in that area, particularly in the US and in the EU. Not so much in Canada, but in terms of the US and the EU, there's a lot of work that has gone on in that respect. And because my focus is on Canada, I'm sticking mainly to that. In Canada, there are general protections, against discrimination that are present in human rights codes. But the problem with those protections is that, number one, they mostly apply first and foremost to state action. They're primarily concerned with state action, especially the Canadian Charter of Rights and Freedoms. So it's, first of all, associated with state action. So actions by private companies or private organizations aren't necessarily covered under the Charter. But provinces in Canada have their own human rights code that prohibit discrimination on various grounds by organizations, by employers, by various people. So we have those protections. But the issue with artificial intelligence is that, first of all, can you really ascribe legal personality to an artificial intelligence system? So it's a case of, we're not discriminatory. We use the same criteria. We use the same system for everyone. But it just so happens that, the screening system screened out some particular candidates and included some. How are we supposed to know that it was based on discriminatory grounds? Because it was by the system, not by any human being, not by any employer. So that's one of the challenges that I actually outlined in relation to those systems. How do you determine liability? More often than not, most people don't even know if they've been discriminated against, because all you just find, take the example of a typical job applicant, all you just find is a response to an email via email saying, unfortunately, you don't meet the requirements for this position. You don't even know who took the decision. You don't know the basis for which the decision was taken. How would you be able to establish that you were discriminated against by an artificial intelligence system based on a prohibited ground? You're not able to, it's difficult to actually establish that. So that is one of the biggest challenges that has been identified in terms of proving discrimination or bias by artificial intelligence systems, especially from the legal standpoint. It's like it's difficult to actually connect the actions of the artificial intelligence system with discrimination based on a particular group of people. Now, there is in human rights law the concept of indirect discrimination, which refers to a situation where a policy appears neutral on the face of it, applies to everyone equally, but it has a different effect on a certain category of people. So in a case, a company policy, for example, appears neutral, but because of some certain factors that are associated with a certain gender or a group of people, they are put at a disadvantage as a result of that policy. So that is prohibited under Canadian law. But again, the question still comes down to the subject of proof. How do you actually prove that? So that is one of the biggest challenges in terms of establishing algorithmic discrimination in hiring. And the second one, which I've actually highlighted here, is the black box issue, where companies or makers of artificial intelligence systems say we don't even know how the system works. In a sense, there's a lot about the workings of the system and how it actually uses data to make decisions that we don't even know about. Now, of course, there's also research to show that that statement is a bit qualified, in the sense that there is information that can be accessed, that can be used to actually make judgments about whether a particular system actually has a discriminatory effect, or use of a particular system has a discriminatory effect on people. But at the moment, especially with relation to discrimination law, it's still a bit of a challenge actually establishing that, because from the enforcement side of things, or from the litigation side of things, you have the issue of who you're going to get as an expert to come and establish that. You know, if there is conflicting expert evidence, who is going to be believed in terms of how this system works. So there are various technicalities that make it a bit of a challenge in terms of how artificial intelligence being used in hiring creates problems, especially from an employment law perspective. Now, quickly move on to the issue of algorithmic management. This is obviously the system, like the name implies, a system where essentially algorithms are the source of decision making in terms of hiring, in terms of evaluation of performance in the workplace, of making decisions in terms of termination of employment. Essentially, algorithms make the decisions. That's the long and short of what that is about. It's an integral part of employment relationships in the platform economy. Say, for example, you have rideshare services like Uber, and food delivery services like Deliveroo and all that. They actually use algorithms in terms of decision making regarding who to keep on the platforms and who remains on the platform and things like that. But it's also increasingly gaining traction in mainstream industries, you know, having algorithms evaluate performances of cashiers, and you know, they're based on their sales, based on their efficiency. So it's gaining traction even in mainstream industries as well. Now, it has its benefits in terms of aiding performance improvement, where if the algorithm gathers data from the workings of employees, you can easily identify what areas need improvement, what areas are, you know, employees are stronger in, and so employees can use such evaluations to actually improve their actual performance. But it also has its challenges. For example, you have a case of, especially in terms of rideshare companies like Uber, we have this issue of algorithmic nudging, where in a sense, an algorithm is essentially telling you, do you want to take one more ride? Do you want to go, do you want to do this work? You know, there's a price search here. You can make more money. Do you want to go for it? And then you end up responding implicitly to that prompting, and sometimes it can have a negative effect on people's mental health, because they end up, because of that incentive, working longer hours than they should, working more and more, and things like that. So that is one of the challenges that can actually be associated with the use of algorithms in terms of managing employee behavior or employment behavior. And so for under Canadian employment law, for the areas that are most affected by algorithmic management, say termination of employment, work hours, they're fairly regulated under Canadian employment law. We have various regulations on work hours, the number of hours that cannot be exceeded, maximum hours, employee discipline, right to notice before termination and things like that, and employee privacy. We have protections on that. But I would just go, because those, I just give an overview of some of the statutes or regulations that deal with that. But I would just go to the challenges, because that's actually the major contribution of my paper, in terms of the fact that it is difficult to actually identify scenarios in which algorithmic management is actually problematic. It's not always that straightforward. Take, for example, the issue of nudging that I just described with Uber. Some people may look at that and say, you know, it's an incentive to make more. How is that an issue? Some say it has an effect on people's mental health. They work more than they should. So it's difficult to actually identify the situations in which it is actually problematic. That's one of the major challenges. And I also talk about the fact that these challenges are more implicit than explicit. You have to go deeper and deeper into actually extracting the real nature of these challenges. And so that's those are the major issues. Now we have the Artificial Intelligence and Data Act, which is currently before Parliament in Canada. It applies to designers and managers of AI systems. The need to identify high-risk systems and mitigate risk. I wouldn't go much into that because of my time, but these are my concluding thoughts that I just really want to leave behind. That's actually my main contribution, which is the fact that employment law challenges created by artificial intelligence, they are less about the technology and more about the user, more about the way in which the technology is actually being used. That is when the challenges really arise. And I also said that dealing with AI challenges in employment law, ironically, may not necessarily require much modification to existing law. It may just require an expansive interpretation of existing law to actually cover those situations where artificial intelligence has a negative effect. And I also said the most important contribution at the end of the day for lawmaking is to ensure a continued existence of individual or corporate accountability for algorithmic output. That's the most important thing. Ensure that there's someone that can actually be held liable for actions performed by algorithmic systems. It doesn't matter what explanation they want to give, but as long as you have someone to hold, there is more incentive on organizations to actually do better in terms of complying with existing employment law. But if there's no one to hold, if they can just get away with, it's a black box system, it's an algorithm, it would reduce the chances of accountability, and it would ultimately exacerbate challenges created by artificial intelligence systems. So, thank you for listening.
Thank you. Let's have a short Q&A about this paper. Any questions, comments, reflections? Yes?
One question. So I remember you mentioned, so because of so many issues with the AI in hiring, you see a limited value of increased transparency of algorithms. So could you elaborate a little more on that?
Well, what I mean by limited value of transparency is that, number one, even if you ask details to be provided about how decisions are made by algorithms, it's not necessarily everyone who's going to be able to understand it. For example, you say, they ascribe, if you talk about algorithms ascribing, data points and data points to a particular group, or the use of data points, for example. It's going to take someone who's not savvy in how these systems work, may not necessarily be able to understand. So it actually depends on the nature of transparency requirements that are actually provided, or the nature of transparency requirements that are imposed. If, for example, you just say give reasons for your decision, that's transparency in a sense, but it's not the kind of transparency that would necessarily do any good, because they can just say, the system uses data to actually make decisions. But the question is, what does that mean? oh, the system actually gathers data and uses it in this particular way. The person who you're talking to may not necessarily understand. So you've provided information, you've talked about how the decisions are being made, but to that person, because of their limited understanding of how these things work. Even for me, for example, as a legal researcher, there's a lot about artificial intelligence and its workings that I don't know. So if people explain to me in a particular way that, yes, it's understandable in a sense, maybe they speak in English, it's understandable, they can actually understand, I can actually understand what they're saying, but in the technical sense, it's still not understandable because I really still don't understand how it actually works. So that's why I said the value is limited. I never said it's of no value, but I just said its value has its own limits. And that's why even in my paper, I talk more about the importance of accountability mechanisms, not just transparency, not just a requirement to give decisions, not just a requirement to be open about your technology and what it does, but the point where you actually make sure that the way by which you are even pursuing transparency is in a way that you want to ensure accountability. So even the desire for accountability should actually guide the way by which you develop a transparency framework. If you just go for transparency based on transparency alone, there is only a limit to which that can actually have the required effect. So that's the point I was actually making there. Yeah.
Some additional measures. Thank you.
Yeah.
Okay, we're going to leave it here. If there are remaining questions, we're going to take them at the end. Otherwise, we lose too much time. So thanks again.
Thank you. Thank you.
So going to a second presentation by Pablo Baquero, also from a legal perspective, also touching upon the issue of transparency, but in another sense. We'll be talking about a kind of an under-researched aspect in the GDPR enforcement literature, which looks at how can we be transparent about the implementation of GDPR fines. And he's done a comparative study in Europe about this. So, Pablo, the floor is yours.
So thank you. I'm going to stand. I think it's going to be easier to do the presentation for me this way. So good morning. It's a pleasure to be here to present our paper on unveiling transparency in data protection enforcement across the EU, assessing the level and quality of disclosure of GDPR fines by data protection authorities. This is a paper co-authored by myself, Aluna, and David Restrepo Amariles. We are from HEC Paris. I'm going to divide this presentation into three parts. In the first part, I'm going to discuss the lack of transparency regarding the implementation of GDPR fines across the EU. In the second part, I'm going to discuss a survey that we conducted, the methodology and the results of a survey with data protection authorities and their practices regarding fines implementation. And in the third part, I'm going to discuss an indicator that we have built to assess the level and quality of disclosure of GDPR fines. When we look at the data protection field in overall, we find an imbalance between the rising number of instruments to harmonize digital rights and the lagging enforcement. Only in the EU we have, of course, the GDPR, but many other instruments harmonizing digital rights. But a number of empirical studies have shown that enforcement is lagging behind. We are going to be focusing on one particular instrument to promote enforcement, which are GDPR fines, seen by many as the linchpin of the data protection enforcement system. Even though there are several empirical studies in the EU, particularly looking at how GDPR fines have been implemented in the past few years, it is unclear to what extent those studies rely on databases that are complete, that are thorough about fines. So our research question is, what is the level and quality of disclosure of GDPR fines undertaken by data protection authorities across the EU? And our methodology was to conduct surveys with data protection authorities in the EU. As I have mentioned, there are several empirical studies already analyzing the field, how GDPR fines have been implemented by different data protection authorities. And those studies have looked at topics such as the number of fines each country has implemented, the GDPR provisions particularly that substantiate those fines, the amount of the fines imposed, the effect that those fines might have on foreign companies, such as US companies, for instance. The overall takeaway from those studies is that there is a significant divergence across EU member states regarding their practices of GDPR fines implementation. Some examples of those divergences: some jurisdictions are implementing a much larger number of fines than others. The monetary amounts can vary significantly as well. The types of breaches that some jurisdictions tend to focus on can be of a very different category. All of those studies, once again, they have a common limitation, which is they rely on databases that are incomplete. So I have highlighted some of the most important platforms that track GDPR fines across the EU, that provide very relevant information, but those platforms themselves acknowledge that they rely on either incomplete or anecdotal information collected by data protection authorities or provided by the parties themselves. So this lack of clarity about the real state of art of GDPR fines implementation can be problematic. We have identified three main risks of this opacity regarding GDPR fines: risks for compliance of individuals and entities, for the functioning of data protection authorities, and for the overall data protection system. From the perspective of individuals and entities, if there is no significant disclosure, they don't have a significant incentive to comply due to the lack of a reputational effect. If nobody knows that you have infringed, this won't create such shaming effect upon you. And consequently, often there are different studies showing that reputational effect can also have a financial effect. So a company that has undergone a scandal might have the values of their share diminished, for instance. So without significant disclosure, neither reputational effect nor the financial effect will be present to induce compliance. From the perspective of data protection authorities, lower levels of disclosure or not significant levels of transparency first make data protection authorities more prone to capture by powerful interests. And on the other side, we are not truly able to diagnose that those data protection authorities are under-resourced, understaffed, or under-financed, because we cannot clearly see what is the kind of work that they have been undertaking, at least in relation to fines. And finally, the risk of opacity also manifests in relation to the overall data protection system, most specifically in relation to a risk of forum shopping. So parties or companies that may want to escape regulatory oversight may want to look for those jurisdictions where data protection authorities have a tradition of not being so transparent or not fully disclosing information about the GDPR fines that they are implementing. And the one-stop shop provision in the GDPR can enhance this risk of forum shopping, because one entity might choose one particular jurisdiction as its main establishment to be located, and by choosing that particular jurisdiction, this will be the place where all cross-border potential activities relating to data protection will be judged, and that could be a less transparent data protection authority. So, to bridge this gap, we have undertaken a survey with data protection authorities across the EU. We sent surveys to all the data protection authorities through their official emails, and then if they didn't respond, we followed up with some of the key authorities through LinkedIn or messaging them through all the available means possible. In the end, we were able to collect data about 23 data protection authorities out of 27 in the EU. So basically, we had 20 countries that are implementing GDPR fines in the EU, 3 countries that, as of December 2023, had alternative national regimes. Those are the cases of Denmark, Estonia, and Slovakia. And 4 countries did not respond to our survey. What are the results of the survey? I'm just going to present the main ones, of course. First, we were able to analyze the different levels of disclosure. So in lighter blue, you can see the countries that disclose all the GDPR fines they implement, such as Spain, Ireland, Belgium, or the Netherlands. Then we had countries such as France, Poland, or Hungary, for instance, where there is partial disclosure. They decide to disclose some of the most important decisions according to their own internal criteria. And then we have countries such as Germany or Austria, for instance, where decisions are usually not disclosed or except in very special circumstances. Our survey has also asked about the quality of the disclosure, that is, when a particular GDPR fine is published, what kind of information is present in that disclosure. We asked for different elements, such as the disclosure of the fine's amount, the applicable legal provisions, the date of the decision. And in relation to those elements that I have mentioned, we didn't find a significant variation. And that's a beneficial thing, most of the data protection authorities, they publish this information when they publicize GDPR fines. But the true differentiator was the shame list. Some countries were publishing, others not, the names of the entities or individuals that have been fined. So we were able to identify 3 groups of countries, those where a shame list is mandatorily published whenever a GDPR fine is made public. Others have a flexible shame list. Upon certain circumstances, those names might be published or not. And some countries didn't have a shame list whatsoever, except in very exceptional circumstances. So combining those 2 criteria, the level of disclosure and the quality of disclosure measured by the shame list, we were able to create an indicator and to identify 6 different groups of countries according to their disclosure practices and to rank them according to those levels of disclosure. This following map shows or tries to rank those countries according to their disclosure practices. In lighter green, you see countries as Ireland and Spain that have a significant degree of transparency, and increasingly in darker tones of green, those countries that have a lesser, best practices of disclosure regarding GDPR fines. To be a bit more clear about what are those groups in those countries, we have created this chart where you can see in group 1, those countries that have the highest level of transparency regarding disclosure of GDPR fines, countries such as Spain, Netherlands, and Ireland. And then until you go to group 6, countries such as Germany or Austria, where, as a rule, GDPR fines and shame lists are not made public. We develop in our paper the assumption that those countries that have higher levels of disclosure, they tend to present lower risks of opacity. So whenever you have significant disclosure, the parties will have more significant incentives to comply because of reputational and financial incentives. Data protection authorities will be subject to less risks of capture by powerful interests, and those are the countries that, because of data protection considerations, would be likely less considered for forum shopping. So in conclusion, our paper has found that there are diverging levels of transparency and disclosure regarding GDPR fines. We associate low levels of transparency with risks of undermining the compliance of individuals and entities, the functioning of data protection authorities, and the overall data protection system. And the diverging patterns of disclosure, in our view, they also potentially undermine a fundamental right to data protection established in the EU Charter, because then perhaps a Spanish citizen might be more protected than a German citizen because of the levels of disclosure of their respective data protection authorities. So that concludes my presentation. Thank you for your attention.
Thank you, Pablo, for sticking to the time also. Questions? Yes, first you and then you.
So thanks, first of all. Very interesting research you're doing. I had one question because Germany was always kind of in the lower bound, but you said you only requested by 1 data protection authority, but actually Germany has 16 data protection authorities. And yeah, it's a bit, I think, interesting how they are like managing it. And I'm a bit surprised. So I was wondering, how did you manage this distinction? Like, did you like write every data protection authority there? Because they do publish annual reports, but I think for research it's really not on a central level. So I just wanted to ask how you were looking into that.
So the information that they publish
Can
normally
you
is on...
can you use the mic?
Oh.
Sorry.
So how do I turn this?
I think it's
Okay. Thank you for your question. So normally the decisions or the information that they publish is on an aggregate level. So like those types of risks that I have identified, like shaming particular individuals or authorities, would not be present in those particular cases. So it's overall data. In relation to the collection of data of the German authority, we have contacted the overall data protection officer that has provided information about similar practices of all the data protection, the 16 data protection authorities. In relation to disclosure practices, they were similar across the 16. That was the official report that we get from the overall data protection officer of Germany.
So you did not individually ask the different DPAs, so you just asked the central data protection officer?
Yeah, we asked the centralized one, and he responded for the 16. He said that the 16 had similar practices regarding disclosure.
Thanks so much. I'm Maria Magierska from European University Institute. I think it's a great paper, and you address this very important issue of the opacity of DPA's functioning. I have one question then about whether you think this more transparency in fines translates into more compliance of the GDPR in these countries, because I saw that this one of the transparent countries, member state that you mentioned was Ireland, and I was just thinking how this method, the fines, the more transparency translates into the compliance. And the second question is also about other measures and whether it's of course outside of the scope of your paper. I'm just thinking what you think. I was wondering what you think about other measures, especially the bans to do the processing and so on, as are more effective maybe rather than fines. Final comment, I think you meant Slovenia, not Slovakia, when you were saying about the countries that don't implement the fines. Yeah, so thanks so much for the great paper.
Thank you for your question. So the case of Ireland is a very particular and interesting one to think about, and it has been a significant food of thought for us, actually. So I think that there are several elements that would be considered, that should be considered. So data protection, if we were considering only this data protection considerations, I think that the transparency would be significant. But there might be many other considerations, tax considerations, issues related to corporate law that might enter into the picture beyond simply data protection. So of course the transparency regarding data protection fines will not be the only thing there. Of course there could be many other measures other than fines. Insofar, however, those are normally seen as the most stringent and more having a more significant punishing effect and deterrent effect overall in the literature. So that was our focus. And I might be missing one additional point. No, did I cover everything? I don't know if you want to add anything.
Okay.
Okay.
Thanks for the questions. Thanks for the paper. So let's go to the next presentation.
Thank you.
So, how to avoid undermining data protection right of citizens. We have discussed this now from a legal perspective. Let's shift to a computer science angle by two presentations. First of all, Claudia Diaz, who wrote a paper together with Halpin and Jaya Brekke. Sorry. Preserving privacy with technology and a data protection analysis of the Nym mixnet. Claudia, the floor is yours.
Thank you very much. I'm Claudia Diaz. I'm the chief scientist of Nym Technologies, and this paper is by my colleagues, Harry, Jaya, and Alexi. They couldn't be here, so I'm filling in for them, although thanks to a last-minute rescheduling, Harry is with us, so he will be able to help with questions if there's any that are beyond what I can answer. Okay, so GDPR, with the rise of online technologies, GDPR had to be put in place in order to kind of protect consumers and users of digital services from egregious abuses of their personal data. So in particular, the collection and use of data in ways that are not according to what people are willing to tolerate. So there's a number of principles like transparency, fairness, accuracy, integrity, confidentiality, data minimization, and so on. I will circle back to these principles in the end to say how this system kind of fulfills these principles. However, even though data protection has been really useful in limiting particularly the more egregious abuses of personal data, market actors have often responded with quite minimum compliance while still collecting and using large amounts of personal data. Often they rely on user consent in order to put in the small letter what they are doing with this data, so there is more transparency, more disclosure, but this has not really resulted in a reduction of the amount of data that is collected and processed and used. Data minimization principles are often, therefore, kind of ignored in favor of consent approaches. And as a result, generally the business models in the internet with respect to privacy are more related to the exploitation of personal data rather than the kind of protection of personal data. So here we take as case study the communication infrastructure, which is the system that we have developed, and then we look at how to kind of embed privacy in it with a data protection perspective from the ground up, right? So why communication networks? They underlie all the online application of services that we use. If we are using any application of the internet, there is underneath the internet infrastructure that is transferring our packets back and forth in order to make this service possible. So it's really a generic infrastructure level technology. As you might know, the internet protocols that we have, TCP/IP and all the other protocols, even though more advanced protocols such as TLS protect the data that is transferred end-to-end with encryption, communications metadata is always exposed by default. So the source, the destination, the timing, the length, all of this data is by default exposed in internet protocols. And because there's many intermediaries in these networks, there's many actors that can potentially have access to this communications metadata to collect it, amass it, and do big data analysis on it. The analysis of metadata is actually very easy because it's machine-readable data, so it's much easier to than interpreting, for example, human text or language. And it can be extremely revealing in the sense of showing the patterns and behaviors on a very large scale, even to the point that they can be even more revealing than content in many instances. So how can we protect this very critical infrastructure? How can we kind of take care of privacy within this infrastructure? So there's two kind of big approaches we can take. We can take an approach that relies on organizational policies. So this is usually what ISPs do. You have a long contract with a lot of clauses that say what they are collecting, who they are sharing it with, and so on. If you don't like it, then, well, maybe you can go to another company, but there are not so many, and they all have similar contracts, so it's not like you have a lot of choice in that respect. And the key principle here is that they will have these organizational procedures and policies and maybe some officers in the organization that take care of ensuring that the compliance is respected, right? But nevertheless, the data is collected, the data is used in large quantities, and is just put in some restrictions so that really bad things are kind of prevented. Now, a different approach is to rely on privacy technology. So here is to build the services from the ground up in a way that is really hard to collect the data in the first place, so that you don't need to then put all these policies and procedures in place to make sure that everything that has been collected cannot be abused. If you don't collect it in the first place, then you don't have this problem. And the idea is that even the service operators who are providing the service to the users, who are handling this information to make the service possible, they should not be able to collect data in a usable way. So for this, we rely on data minimization in order to achieve privacy by design and by default. So some of the concepts here are that we want to kind of build this privacy by design and by default at the infrastructure level without relying on kind of by default for everyone, without having to get consent from people in order to collect their data and then use it. So we kind of reduce the burden of responsibility on the end user, who in many cases is not really prepared to realize what they are agreeing to. Furthermore, we would like to also see a market for privacy technologies emerge, so something that is not relying on the exploitation of personal data, but rather on the provision of privacy services. So how do you do this? One of the key elements in this kind of solutions is the distribution of trust. So you don't want to have a central point of failure, which is a central organization or point where all the data is collected in the clear, where that then can be the subject of either abuse from internal, from insiders or from outsiders who break into the system. So in that sense, no single element or operator in the system should have kind of the pieces of the puzzle to have personal data that is relevant to users. So on a more technical level, this relies on cryptographic protocols, both multi-layer encryption, but also more advanced credential protocols that enable selective disclosure. And what you cannot protect with cryptography, because cryptography can go a very long way, but it doesn't protect absolutely everything, particularly when it comes to metadata and communications metadata. So then there's the use of obfuscation techniques, such as timing obfuscation and cover traffic, that kind of introduces noise that makes it very hard to perform traffic analysis and understand what is going on in the network. So just to give you a summary of an idea of how the network works, it has four core components. So one component is the Nym mixnet. I will speak about that in a moment a little bit more. This is a decentralized network that basically shuffles packets back and forth. And it does so in a way that is very difficult for anyone, even if they are observing the full internet, to figure out where packets are going. So who is communicating with whom and how much data they're exchanging. In addition to that, there is the Nym credentials, also called ZK Nyms, that enable selective disclosure. So this allows you to have, for example, payments or authorization to use the service, but without the need to disclose any information that is not, for example, this person has paid for the service and is authorized to use it. So you really can minimize as much as possible the disclosure of information. There is also an incentive system, because this is a distributed system where everybody, many people can become providers of the system, operators of the system. So you need to have some sort of business model that is not relying on gathering the data and then selling it to third parties or using it for advertising. So there is an incentive mechanism that basically distributes financial rewards to the operators that are contributing to the service. And we rely on a blockchain as an element for kind of a broadcast channel where all the information that is relevant for the system operation is recorded, so that everybody can access the information and everybody sees the same information. So this is kind of in order to ensure that we all have a consistent view. You have many entities collaborating together. They all need to have some repository of information that they can all rely upon to coordinate. So just a few more words about, this one. So just a few more words about the Nym mixnet, how it works. So it's multiple hops. So basically between you and your destination, you will not connect directly as you do now, because then any intermediary can see who you're connecting to and how much data you're exchanging. So there is multiple intermediaries. Actually, every packet goes through a different route. So it becomes very difficult to trace connections end to end. In addition to that, it has covered traffic, so not all the traffic that you see is real traffic. Some of it is dummy traffic, so that it creates a noise that makes it very difficult to figure out whether people are even communicating or not. And there is timing obfuscation at every hop, meaning that packets are reordered, so that even if you're seeing the input and output of every intermediary, you're not able to correlate inputs to output based on timing. You're of course not able to do it based on the content, because there is a cryptographic transformation of the packets, but even based on timing, it becomes very hard to do it. Now, the good news is that this system is horizontally scalable, just as the web. If you have more users, more packets, you just can add more servers, and they are able to handle more traffic. The credential crypto system has a number of properties. So one is unlinkability. So basically, you obtain this credential, and then you use this credential, maybe says this person is registered, subscribed to the system, and has paid for a month of usage up to whatever, 100 gigabytes of data that they can use, right? So the unlinkability ensures that the use of the credential is unlinkable from the issuance of the credential. So you paid for this credential, and then when you're using it, nobody can say, okay, this person using is the same that paid, so this provides really nice privacy properties. On top of that, when you use the system multiple times, these different users are unlinkable from each other as well, so that you're not able to build like kind of long-term profiles by looking at activity over time. This type of credentials, they have what we call selective disclosure properties. This is kind of general in many of these cryptographic credentials, which means that you're able to prove properties about yourself, sometimes, for example, certified by a third party, and minimize really to prove the properties that you want and not disclose any additional information. So for example, you could prove your credential is still valid. You could prove your age is over than 18, but you wouldn't be giving away your exact date of birth, for example. And one thing that is special about this particular flavor of credentials is that they are decentralized, so that they can be issued by a set of collaborating entities instead of having like a centralized issuer. So in terms of the market and the economics of the system, to give you like a rough idea, the goal is that users will pay for the service. So they have a payment that gets converted to certain tokens. This is to make this the value flow within the system. And then they obtain access credentials that are completely de-linked from their, if they paid with a credit card, for example, this credential they obtain would be completely de-linked from any payment information. The service operators, on the other hand, there are different kind of operators. I don't have the time to go into all the details, but there is operators that shuffle packets, that route packets of the users. So they are kind of rewarded in these tokens that they can exchange for real money, depending on their contribution to the system provisioning. And similarly, the other providers, such as the validators that maintain the blockchain and ensure the consistency of the information in the system, they are also kind of rewarded on the basis of their collaboration and their issuance and signing and verification of credentials, yes. Stakeholders, on the other hand, they kind of help manage the system, kind of with a reputation. The stakeholders are able to support operators and get in return rewards if the operators are doing a good job. If not, they won't. So coming already to the end. So if we look at the principles of GDPR, we can see that this quite nicely and effortlessly can fulfill many of them. The source code is free and has extensive documentation, so it's quite transparent in that sense. Because everything is encrypted, there's no way to discriminate. You don't even know whose packets you're handling or what type of traffic it is. Integrity and confidentiality is obviously protected through cryptographic, through a suite of cryptographic protocols and algorithms. Data minimization is the whole core of the system. We are ensuring in this design that only the minimal information needed to provide the services is there. Purpose limitation also becomes easy when you're not collecting vast amounts of data. Lawfulness, in this system, it's not possible to have backdoors because it is not technically feasible to kind of put together all these pieces of information. But currently, there is no obligation to include backdoors to enable the anonymization. And accuracy is kind of out of the scope because we are not really handling content. So just some open questions that remain. The GDPR usually deals with application level data, but what happens with the network? IP addresses are obviously personal data, but what about patterns of packets that can be very revealing and indirectly identifying? What is the status of this kind of information? Is the mixnet a controller or a processor? It can be thought in both ways. So what is the right framing? And which are the articles that are most appropriate to kind of look at the GDPR compliance of technologies such as this? Should it be Article 5, as is done in this paper, or more looking at data protection by design or technical organizational measures? And with this, I conclude my presentation. Thank you very much.
Thank you, Claudia. We have time for one short question at this moment.
Of the tokens that operators receive as a reward.
So the blockchain is, we are relying on existing, we have customized and deployed, but we didn't develop from scratch a new blockchain. We basically just need like a fast system that can, have the information available for everyone. For us, is really like a log of transactions, and then a broadcast channel as well for information about the network, such as parameters, that all the nodes or public keys that you need to prepare the packets and stuff like that. So all the information that should be available to all participants is included there. The second part of the question?
The tokens, so it's the nature of the tokens that operators receive as a reward. Is it the native token of the block?
Yes.
Okay.
Yes. Yeah, thank you.
Okay, sorry, we have no time for the next question, but perhaps at the end still. Thanks again, Claudia. Then going to our final presentation, also from a computer science angle, by Alexandre Debant, a paper together with his co-author Lucca Hirschi on reversing, breaking and fixing the French legislative election e-voting protocol. Very relevant, timely, given the European elections coming on, I would say, and also the CNIL-INRIA Privacy Award winner. So congrats for that also.
Thanks. So today I will present.
Does it work? Yes, it works.
So today I will talk about, we present you the work we did with Lucca, about the protocol, the system used for the last legislative election. So just a bit of context. So this is, the legislative election is a big election in France that happens every 5 years to choose I don't remember, maybe more than 500 deputies. And for all the French citizens that live abroad, they had the possibility to vote online using electronic voting systems. And so we wanted to analyze the security of the system that has been provided to be sure that it's secure. So to do this, so the first step the first step of our work was very easy, was just to identify the different roles, the different agents involved in the system. So this is very easy. You just have to look at the documentation of the system. So interestingly, we have the voting server. So the server that will collect all the ballots is operated by the French Ministry for Europe and Foreign Affairs. There is an encryption scheme that is used, and the decryption key is not held by a unique entity, but is shared between different parties. It's shared between representatives, so this is what you usually have in paper-based election. The trust is shared between the different assessors and so on. And in the system, there was a third party to verify something. I will come back on this later. And because we want to analyze the system, the first question was how all these entities communicate, what are the messages that are exchanged. And unfortunately, there was no documentation that was describing the system. And so the first contribution, the first step of our work was to first obtain such a specification by reversing the JavaScript sent to the voter, because for sure we have no access to the voting server. So what we did is just we received the JavaScript, so we opened the web page during the election. We collected all the material we received, and we tried to reverse what is computed, what is done on our voting device. So based on this, we then do a security analysis. So we show that there was different attacks, so different vulnerabilities. We are not saying that these attacks have been exploited. We are just saying that they might have been exploited. So then we proposed some fixes. We disclosed our findings to the different stakeholders. And based on this experience, we tried to take a step back and have some recommendation for future election of future systems. Okay, so first, how the protocol works. So this is maybe a bit technical, but I try to keep as simple as possible. So when the voter wants to vote, what it does is select its choice on his voting client, so typically in his browser. The vote is then encrypted with an encryption scheme with the different key shared between the different trustees. So the encryption is mainly used to provide privacy. And with the encryption, the voting server doesn't know who I voted for. Then the ballot, when receiving a ballot, the voting server put it in the ballot box. interestingly, there is one ballot box per city, typically, in this system. And the server replies with a receipt to acknowledge that it has received the ballot, and the ballot has been added in the ballot box. At the end of the election, all the trustees receive the content of the different ballot boxes, and they can collectively decrypt. So the ballots are not individually decrypted, they are aggregated and then decrypted to guarantee privacy. And the third party here is used to verify that the computation has been done correctly. So typically there are proof of correct decryption and so on, and all these proofs are verified by the third party. And another usage of the third party is to provide a service to the voter to verify that their ballot has been counted. So at the end of the election, the voter can use their receipt to verify that the ballot has been included in the tally. So with encryption, we protect privacy, and with this service of verification, we protect verifiability. I will just define it just after. Okay, so this is how the protocol works. And the question now is what security do we have? So the first family of security properties we have in e-voting mainly relates to privacy or confidentiality. We had a look to the French law and to the different recommendations dictated by the French Commission for Data Protection, so the CNIL. So among the four properties, the most prominent one is vote privacy, so no one should know who I voted for. And in the law and in the CNIL recommendations, there is also everlasting privacy, meaning that the vote should remain secret even in the future. But we did not study this property because it's quite trivial to achieve since nothing is public in the system. So the third party collects data but never publishes them, so it's very easy to achieve. So in our study, we focused on vote privacy. The second property is what we call verifiability. So this is a property about integrity. So again, in the literature, there are many properties. But in the law mainly focuses on recorded as cast and tallied as recorded. So tallied as recorded just means that the result corresponds to what is in the ballot box. So the decryption is correct, typically. And the recorded as cast focus on the fact that if I'm an honest voter and I cast a ballot, then my ballot will be added correctly without modification and so on in the ballot box. Typically, the law and the CNIL recommendation do not focus on what is done on the voting device. So typically, if the voting device is compromised, and the voting device may modify my choice. But this is more or less acknowledged in the law. Okay, so these are the two properties, and most of the time we stop here. But when we want to conduct secret analysis, we want to go one step further, and we need to define what is the threat model, so what the attacker may corrupt. And here I'm showing you the usual threat models, so for vote privacy and for verifiability. And usually in the academic paper, we always assume that the communication channels may become compromised, just because over the internet you may have middle box TLS and so on to spy on the traffic. Usually in e-voting, we also assume that the voting server is compromised, because the voting server is controlled by the organizer, so typically the government, and maybe you don't want to trust the government to publish to act honestly during the election. And in a traditional paper election, you don't trust the government. If you want, you can go in the polling station and observe what is done during a complete day, observe the tally phase and so on, so you don't need to trust them. Okay, so this is the trust model, and we show that our attacks may even work if the voting server is honest. So the attacker just needs to spy on the communication channel. Okay, so just to give you some ideas of what are the two main attacks or flaws we found. So the first one is an implementation bug. So this is how I have described the protocol in the previous slide. And I said that the voting server replies with a receipt to the voter. a receipt that corresponds, the voting client checks that this receipt corresponds to the ballot that has been cast. Unfortunately, if you have a look to what is implemented in practice, the voting server does not send back one receipt, but it sends back 4 receipts. And the consistency check is done only for 2 of them. And unfortunately, the receipt that is displayed and sent finally to the voter is a receipt for which the consistency check is not done. And so, based on this observation, the attacker can just modify the ballot. So typically, instead of sending a black ballot, send a red ballot. Modify the receipt sent to the voter. So modify those that are not, for those there is no consistency check. And everything will pass correctly. Nothing can be detected. So with this attack, the attacker, so here I printed with voting server attacker, but it can also be done with just an attacker controlling the channel. The attacker can modify the result of the election just by modifying all the ballots, as you want. So this is related to an implementation bug. Instead of sending just 1 receipt, send 4 receipts. Some consistency checks are missing. The second attack we found is against vote privacy. So here, the attacker will be able to learn how I voted for. And this is not an implementation bug, but it's more a design vulnerability in the design of the protocol. And this is related to the fact that there are multiple ballot boxes. Okay, so in this attack, because we have multiple ballot boxes, we have 1 ballot box per city. You have some cities in which you have only a few voters. So it typically means, if I remember correctly, there was 5 or 6 voters who cast a ballot. And there are larger cities. And what you can just do is just move the ballot of a target voter from a large city to the ballot box of a small city. And doing so, you can easily learn at least a bias, but in some context, completely learn the vote of the voter. For sure, here you can target only some voters, so typically 1 voter per small city, but it may be enough in some cases to learn what you want. And even more, you can, even instead of trying to learn the vote of 1 voter, you can also try to coerce a set of voters and move all the coerced voters to the same ballot box, and depending on the result, learn what has been voted. Okay. So we disclosed these attacks to the different stakeholders, and all of them have been fixed, sometimes non-optimally, for the election that have been rerun in 2023, because there was some election that have been rerun. So I just finished quickly with just
to round up, and I was going to run out to get you.
Yeah. So just quickly, so if you have a look to the documentation provided by the vendor, they claim to have derived a system from Belenios, which is an academic system that is affected by none of these attacks. But they had to first adapt the design of the protocol to satisfy some requirements of the concrete world. Typically, multiple ballot boxes, be able to download receipts, and so on. So they first introduced attacks at this step, and then they had to implement it. So they had to re-implement it because they modified it. And they introduced other attacks. Okay, so based on this observation, what can we do? So first, we all know that designing a secure protocol is very difficult. So it may be interesting for the academic researchers to design protocols that takes into account all the operational constraints. Typically, it's not a shame, but it's sad that Belenios does not support multiple ballot boxes or does not provide support for downloadable receipts and so on. And the second point, and here I'm not talking about, but there is also issues related to the verification of the eligibility of the voters. And the last point is regarding the implementability. So implementing a system is difficult. So we push for more transparency, as it's done in Switzerland typically. In Switzerland, they require that all the system is open source and open access. And maybe one key elements that you should keep in mind is that when you want to push for transparency, or you want to be sure the system is secure or not, you need to first think about what components are trusted. And these trusted components are the most critical ones. And typically for e-voting, the voting client, because it's trusted, is much more critical than the server. Server is critical for robustness, for availability, and so on, but for security, it's less critical than the voting client. Okay, so I will stop here.
Yes, we have to stop. And if you can
I
finally
just
conclude.
wrap up of what we've done. So.
Okay, thanks, Alexandre. Unfortunately, time's up. If there are questions for Alexandre or the other author, please address them after the panel. Thanks for joining this academic session, and hope to see you around in the rest of the conference. Thanks again.